Okay, good morning, everyone, and thanks for joining me again for what is this second of these coffee briefings that we've started to do. I'm hoping that everybody can see and hear me again. I know we had some technical problems with GoTo last time, but I think we're just about there and we're all used to it now. So I'm hoping this is all working. As per last month, I have got chat box and Q&A that I can see, so please do feel free to chip in, talk to me, communicate with me, disagree with me if I say anything today that you might want to challenge. Yeah, so for those of you who joined me last month, you'll know that this is a series of these sessions that we're starting to do, exploring the employee life cycle, and that we started last month with recruitment and some of the legal issues that arise out of recruiting and bringing staff on board in the first place. I thought the natural next place to go with today's session was to start to look at employment status, contractual relationships, and a few issues around both of those. So that's largely what we're going to be exploring today. Again, as I say, please do feel free to chip in and interact. We had some great interaction last month, so I am hoping that we will get similar today. So what are we actually going to cover for the purposes of today's session? Well, I thought I'd start by talking through employment status, why that's an important issue at the moment, and why it's become an increasingly complicated one in recent years. We all know that it's cropped up around gig economy issues and that maybe some of our older ideas around employment status and those much easier designations have started to change. So we'll look through some of the distinctions between employee, worker, and the self-employed, and I will touch towards the end of the first half of this session on how the tribunal is starting to assess these differences, and we will look at some of the existing case law on those. For the second half of the session, we'll move more into contractual relations, and for obvious reasons, we'll focus on actual employment contracts and how they sit and what needs to be in them. We'll look at some of the additional and optional clauses that might be able to go in there as well, the overlapping mandatory provisions. And I've not put it on this slide, but right towards the end of the session as well, I'll touch on a few things that look as though they're going to change in the next year or so, and things to be aware of, because January is a good time to start reviewing employment relationships in the same way that we review everything else and all of your paperwork. Assuming there are no questions on what we're going to talk about, I will dive straight in from there, and we will see where this goes. So starting point really, why are we interested in employment status? Why are we bothered about it, and why does it actually matter? For any of you who attended the in-person session back in October at the Vitality Stadium, you will be aware that I spent about 45 minutes talking about constructive dismissal as part of that session. And I spent the first sort of 15-20 of that really talking about the underlying idea of the employment relationship as fundamentally being a contractual one. And it very, very much is. We sort of think of it as this special relationship, but historically and legally, it's fundamentally just a contractual one. As an employee, as a worker, indeed even as a self-employed individual, I am agreeing to do work in exchange for money, and that is fundamentally a contractual relationship. And ultimately, where that has developed over time is the concept of status has really become the backbone of that relationship, and the difference between an employee, a worker, and a self-employed individual really stems on what that contractual relationship looks like, but also on the flip side, the benefits and protections that come with it. So if you look back at older law, particularly before, well, I say older, but actually you could probably go as late as the 1970s and you'll still see case law that talks about the master-servant relationship. And our entire concept of employment law into the modern era has sort of stemmed from those very domestic servitude relationships and the need to protect people who are in that sort of dynamic, as it were. Where case law and statutory law started to develop is ultimately a recognition that, yes, this is basically a commercial contract. Somebody is being paid in exchange for doing work, But actually, in an employment relationship, the employer is in a very powerful position. They have a significant degree of control over the individual. And what we need to do is recognize that control and legislate and regulate around what can and cannot exist in terms of that contract. And it's something we'll come on to a little bit later again in the session. So as I say, we're interested in status because status dictates ultimately the rights, entitlements and obligations that the two parties have in whatever dynamic may exist. And as we know, for employees, those rights are significantly higher than they are for the self-employed, for example. And as I was sort of intimating there, it is a complex area. There's absolutely no doubt that status has been something that people do get wrong, have got wrong, and it is easy to get wrong. Let's not forget that somewhere along the line, somebody paid a lawyer a hell of a lot of money to tell Uber that all of their drivers were self-employed. And they were wrong here, they were wrong across Europe, and they were wrong across some of the states as well, which is incredibly difficult to do. So there is this overlap between some of this older law, the new law in the Employment Rights Act and how they started to interplay into each other. And then inevitably there is some conflict between UK and the UK implementation of EU law historically. And that is ultimately going to be an issue moving forwards, I think, as well. And the extent to which historic EU ECJ judgments are actually going to continue to impact on our worker status. Other reason, of course, that it's important to know employment status. I will not dwell on IR35 and the tax implications for very long, but that is obviously an important issue, particularly for people who believe they're self-employed or are genuinely self-employed. And again, where there is this conflict in existing law, it's worth remembering that for the purposes of tax and employment rights, it is perfectly possible to be both one and the other. The test is principally the same, but it is applied slightly differently between the tax jurisdiction and the employment tribunal. So thinking about status, let's touch on an employee. Most of us who are working in a business are probably employees. And ultimately, the very helpful definition of an employee that you will find in the legislation is somebody under a contract of employment. The questions ultimately become, what does that actually mean? And that's where we've had a lot of the case law start to develop since 1996, and the Employment Rights Act started to introduce these definitions. As I was saying at the sort of start and the introduction to this, I suppose what we have to recognise with an employee is that they're under a significant degree of control by an employer. Fundamentally, an employee is told precisely when to do their job, how to do it, where to do it, and indeed you'll often go as far as many of us will be familiar in an employment contract with that very broad provision that says you will do your job, but you will also do anything as reasonably directed by your employer. So there is a significant power imbalance here in the employment relationship, and that is what statutory employment law has historically tried to recognise. So one way of looking at an employee, and I've sort of drawn this from the case law, is that they work significantly under the direction and under the control of the employer. And that really does draw back to some of the points that I was just making, that an employee is told very much how to do their job under this sort of very significant degree of control. The counterbalance to that, of course, is that an employee has significant statutory rights. We know after 2 years they have unfair dismissal protection. We know they have redundancy pay entitlements. We know they have all of the various statutory rights relating to family-friendly leave, health and safety rights, etc., etc. All of these things, which again, if we look back historically, we can see the logic in them being there. An employee ultimately needs a job, they want to be paid, they need an income. It's a very easy relationship to abuse if it's not well legislated and well protected. Stepping sort of down then, and we reach worker status. All employees are workers, not all workers are employees. And that's because this definition of worker is arguably more wishy-washy than the definition of employee. It derives from a combination of EU and our implementation of EU law, and you'll often see it as a definition used in things like working time regulations, some of the family-friendly protections, and what those various statutes ultimately say is that a worker can be someone who's under a contract of employment, but also someone who is engaged under a contract to provide work or services. And it's that sort of second limb, the limb B extension of worker, that covers slightly more people. To me, I think the best way to sort of think about workers is to look back at that degree of direction, degree of control by the employer, and slightly loosen it. And what we have with a worker, I think 0 hours workers are a good extreme example to use. Ultimately, what's missing is that obligation to turn up exactly when you are told, always, and to do that on a regular pattern. 0 hours workers are the archetype of this. There is absolutely no obligation on them to do work at a certain time, and there's no obligation on them to accept that work if it's offered to them. The only thing that does remain in place, I suppose, from employee, and it becomes a distinction with the self-employed, is that when they do that work, it is that individual who is expected to do the work. It is a personal contract between the worker and the engaging party. And I think the definition of worker and employee is such a grey area that it always boils down to the individual circumstances, as we'll come on to later. But for me, that distinction is around the very specific degree of obligation around work as and when it's offered. So as a result of this, we have slightly fewer rights that are assigned to workers. We know they're entitled to things like minimum wage, holiday, rest breaks. What they don't get is the unfair dismissal protections and some of those higher level things that we might associate with an employee who is much more permanently and stringently tied to their employer. Particularly, I suppose, of more use now that we know that worker contracts can't contain, particularly 0 hour worker contracts, can't contain that exclusivity clause. The degree of flexibility is counterbalanced by the reduction in those rights and entitlements. As I say, it is a complex area. It's an area that lawyers, that judges have got wrong for a very long time. And I do think there's this complicated overlap between worker and employee that still hasn't really been reconciled properly in UK or EU law, really. And then that brings us down to the self-employed again. And I know some people on this call will be self-employed because they run their own businesses and will be sort of self-employed tied to that. And I suppose the basic definition of someone who is genuinely self-employed is that they undertake work for someone else and on their own terms. Great typo in that first bullet point, isn't there? It's an incomplete sentence. But ultimately, the idea of a self-employed individual is that they are working for themselves in their own way. And if we think back to sort of pre-gig economy and all of these quasi-self-employed individuals, and maybe go to where we would think traditionally somebody is actually self-employed, this all starts to be a lot clearer. You take, for example, tradespeople, builder, plumber. You instruct someone or you engage someone to build your conservatory or your kitchen extension, they are almost certainly self-employed. You might, as an individual, contract with the company. The builder who runs it will almost certainly be self-employed associated with that company. And ultimately what you do is you instruct, you engage somebody to get a job done. It's build the conservatory, do my kitchen extension. And therefore they are, as I've said in the second bullet point, they're operating a business or providing a service in a sense individually. They are free to subcontract that work. And this is really the principal definition of someone who is self-employed. That builder, if they need an electrician, is subject to your contract with them and cost, absolutely entitled to bring an electrician on board to do the work that they can't do themselves. And that's, I mean, it's a useful analogy for a self-employed individual. The other classic patterns I sort of indicated that some people on this call might be those of you who are running your own businesses as HR consultants, for example, partners in traditional partnership models such as law firms or accountants. The people running those are usually self-employed, and that is because principally there is no distinction between a partnership, traditional partnership anyway, and the individuals who make up that partnership. And again, that model works for a lot of people. It works in that traditional sense, and the self-employed have taken on their own responsibility for tax. We know there's some sort of national insurance benefits, for example, but they have no rights granted outside of the contract. So if you don't have a written contract with these individuals, there is no additional governing principles behind this beyond simple contract law. The only claims that a self-employed consultant has, or that the engaging party has against the consultant, are breach of contract. And therefore, as we'll come on to, it's actually quite important to have those terms quite clearly laid out. Otherwise, they're, of course, not established anywhere. Again, I appreciate not a particularly easy area to cover in 15 minutes, but any thoughts, comments, anything anybody wants to chip in at this time on what is, I know, a very brief overview of those three status points? No, if there are any questions, by all means, as I say, put them in the question Q&A box, and I'll come to them in due course. But I can't see anything cropping up, so I will move on. So we move on to actually determining status. Now, what is it that the courts look at? What it is that the tribunal looks at, and what is it should we be thinking about? Well, the first question, let's look at self-employed versus the other two. And this really draws on what I was just saying about the fundamental definition of someone who is self-employed. It is that obligation to perform work or service personally. If that's not there, then they're not self-employed. Sorry, they're self-employed. Just to clarify, the definition of personal service is what defines an employee or a worker. The contractual relationship is between the individual and the engaging party to actually perform that work. Take an employee as an extreme example. I could not phone our managing partner tomorrow and say, Matt, I can't be bothered to come in this morning, so I'm sending so-and-so to do it for me. The obligation is absolutely on me to do the work, in exactly the same way that in return, the firm is obliged to give me work to do. The only acceptable reasons that I cannot turn up and do my job are ultimately that I've been terminated, that I'm sick, that I'm on leave, or that there is some reason why lawfully I can't turn up. There's not very many others. A self-employed individual has obviously much more control over that. They can choose to turn away work, they can choose to decline work, and the particularly important one, as I've said on the second bullet point there, is this substitution idea. And inherently, for all the reasons that I was discussing using the builder and the electrician as an example, a self-employed person has to be able to substitute in some way. There are, I suppose, two ways of looking at this. There's that example that I just gave of the builder, the electrician, the subcontracting of trade work. The other sort of classic self-employed model would be sort of salon staff or hairdressers who rent a chair, rent a space, and provide services as and when they feel they need to, as and when they want to, for the course of the length of the contract. Two models within that are sort of the chair space hire model, or the you will come in and provide this service for us model. In either case, the idea, of course, is that the freelancer, the self-employed individual, is entirely free to say, I'm getting somebody else to do it on Tuesday because I want to. I will be responsible for paying them. Company, I will still invoice you for their time, but it's my job to pay that individual. The thing about substitution, if it's there, is it has to be viable. And it has to be realistic. And this is where some of the gig economy cases really started to lose out. because they'd had very clever lawyers try to draft in these substitution provisions, turned up in court and went, look, judge, there is a substitution provision, therefore they must be self-employed because they could have sent somebody else at any time. And that's our fundamental definition. And what the courts are quite good at doing is looking at that situation and going, fine, it's there, it may well be written down in a contract somewhere, but could it actually happen? Are you actually saying that if this person had said, no, I'm not doing it tomorrow, I'm sending so-and-so instead, you would have allowed that, that would actually have been considered and it would have gone ahead. We will come back to that in due course, but I think where the fundamental difference for me is with a self-employed individual is those two areas: the ability to turn down work almost at will, and the ability to substitute accordingly. So that leads us to the slightly more complicated question of the difference between a worker and an employee. And as you've probably picked up at some point in the last 15 minutes, this is not the easiest thing to do or define. When the Employment Tribunal considers these questions, there's a handful of factors they look at. They can consider anything that they deem relevant, but they will look at things like degree of integration. A self-employed individual, for example, may well be using their own email address. A worker or an employee is much more likely to have a business domain, a business email address that they use. Pimlico plumbers lost out because, of course, Charlie Mullins expected all of their plumbers to turn up in his branded van with his branded kit, etc., etc. So that's one aspect they will look at. And they will also look at these two things that I've been discussing all the way through: degree of control and the obligations that are in practice there between the parties. The more control you have over an individual, the more likely they are to be deemed an employee. And that makes sense if we think right back to what I was saying at the start, and where historically some of this starts to come from sort of domestic service relationships. If you are expecting somebody to be available to work for you between 9 and 5, Monday to Friday, with an hour for lunch every week, apart from their annual leave and sick entitlement, you have a significant degree of control over that individual. You can tell them what to do, when to do it, how to do it within reason during those hours, and the expectation is that they will perform it. That is what an employment contract is. And therefore that degree of control is reflected in the tribunal looking at a situation and saying, well, if it's there, you are treating this person as an employee, therefore they are. The obligation is an extension of that. It does kind of cut both ways. And this is, where does the contractual obligation sit? Am I, as an employer, obliged to give this individual work? And if I give them work, are they obliged to do it? And that, again, is where you sort of get this distinction between employee and worker, in that a 0 hours worker, again, to use the extreme example, is absolutely free to say, no, I don't want any shifts next week. In exactly the same way, the employer is not obliged to say, you will definitely be working these 12 hours. And I think that's where the real grey area sits. That's where, if there's a distinction, there is one. I don't know, there has been talk about unifying these under a future government and just having one concept of worker and one concept of self-employed. I can't see that happening in the immediate future. Would it tidy things up? Maybe. Would it just create a lot more complications? Probably. We are where we are at the moment, unfortunately. So with all that in mind, we've got sort of these two historic cases that people think about when you talk about status. AutoCleanse a few years ago, and the Uber case is probably the most famous one more recently. AutoCleanse, a Court of Appeal case; Uber, a Supreme Court one. And I think what's interesting is everybody sort of goes, Uber created this new law, it really defined it for us. And actually, in many ways, it's sort of just confirmed AutoCleanse. And what AutoCleanse and Uber both did was look at all of those things that I was just saying. And what they sort of concluded was this was very much the tribunal going, okay, we're assessing a contractual relationship here. The employment relationship is a contractual one, fine. Historically, normally in every other aspect of contract law, what is written on the piece of paper matters because it's expected that that's what the parties intended to do. And we will generally follow that. We will look at the contract first, and we will make at least an interim view based on that. And that's fair enough. We want contractual certainty when we're buying a product, for example, or when we are engaging someone to, I don't know, build a conservatory. We want to be clear what those contractual terms are. But, says the tribunal, and then says the Court of Appeal, and then says the Supreme Court, that's not necessarily the case in an employment contract, because we are potentially protecting very important statutory rights that are there for a reason, to protect employees. And therefore, what Uber and AutoCleanse had both said is that the courts do have the power and the ability to look at the contract and go, well, it's fine. It might say they're self-employed. It might have all of the warranties, all the indemnities accordingly, but sorry, they're an employee. Because, says the court, basically, if it's got 4 legs, fur, and barks, it's a dog. If it ticks all of these boxes for an employee, it's an employee no matter what the piece of paper says. So the important takeaway really from AutoCleanse and Uber isn't necessarily where that definition sits, but actually the court's power to look at the relationships you've got with staff and go, well, okay, everybody might have thought they were self-employed, but you're wrong. They're an employee. And the outcome of Uber and AutoCleanse for a lot of people was actually, let's review what's happening on the ground here and make sure that the people who we are calling self-employed are genuinely so and that we're treating them accordingly. Okay, that is pretty much all I want to say on status. Again, I'm still not seeing any questions coming in, which either means nobody's listening, I'm confusing everybody, or I've covered everything that I need to. So I'm going to choose option 3 of those, unless anybody says anything, and just assume I'm doing a fantastic job. But if anybody has got anything they want to say now on status, any particular questions they might want to ask about it, again, please do. I've got sight of the Q&A, I've got sight of the chat box. Just give a couple of seconds to do that. If not, we can pick up at the end. No, I will take that as a good sign then. Thank you. I didn't want any complicated questions if I could avoid them. So let's move on and talk about the contractual relationships then, with all of that in the back of our minds. So as I've been saying all the way through, all of these relationships are ultimately contractual in nature. A self-employed one, absolutely. It's a commercial contract. It is between either business to business to provide work and services, or an individual to another business similarly to provide work and services. A worker contract, an employment contract, is exactly the same thing, save that it is a personal obligation to do so, and it's one that's highly regulated by law. So we want employment contracts, we want self-employed contracts for one of 2 reasons. Either we're complying with our legal obligation, for example, our Section 1 Employment Rights Act duty to give that information, or we're governing other aspects of the relationship that we feel we need to make sure are in there and are properly recorded. The second one, particularly important for the self-employed, because it's the only place that there's any obligations and rights to set out. Even if you don't have a written contract, as we'll come on to later, if you've got an employee, they've still got all of their statutory rights. It doesn't matter. But for the self-employed, it's the only place there is anything. So if you want some kind of mutual 2-way benefit burden type relationship with a self-employed person, make sure there is a written contract in place. I'm not going to dwell too much on those because self-employed consultancy agreements are quasi-employment law, and the more interesting area for most of us, I think, is actually what we do with employees and workers. So first thing to think about, though, is a wider contract law concept of express versus implied terms. Express terms are the ones that we've got written in the document. I will pay you £10,000 in exchange for building my conservatory, to keep drawing back on the example I've been using before. An express contractual relationship is formed anytime basically you write down something which you intend to be legally binding on both parties, and that goods or services are provided in exchange for some kind of consideration. Express terms in an employment contract, all the ones you will expect. work through your template in your head. Everything that's written down there is an express term. Contrast this with implied terms. Either statute or case law will tell us that there are things that should be read into a contract. And whether you've got them written down or not, implied terms will be there because the courts or legislation say they have to be. In an employment contract, all statutory rights are implied. We know this. If you try to pay somebody £6 an hour and they are an employee, doesn't matter that your contract says £6 an hour. It will be whatever that person's national minimum wage is if it's higher. Similarly, holiday entitlement, statutory sick pay, all of these things, the implied term is actually that you will comply with statutory minimum standards. Other implied terms include things like the duty of fidelity. So this is the idea that your employees will be faithful to you ultimately, that they will not, within the duty of fidelity, you'll sometimes get that they won't moonlight, that they will act with good faith and in the best interests of the business while performing their duties, those sorts of things. Duty of confidentiality, there is an implied one of these in employment contracts. Strictly speaking, it applies for the time they're employed, and what it means is they will not make use of your confidential information for their own benefits or to adversely affect the business more broadly. And the fourth one example I've given there is the one I talked about during the in-person session because it gives rise to constructive dismissal claims, an implied term of mutual trust and confidence. It's a two-way thing, and ultimately what it says is neither party will act in a way that is intended or likely to be detrimental to this sort of idea that an employee and employer should have trust and confidence in each other. Breach of that one is what gives rise to, as I was suggesting, constructive dismissal claims for an employee. The other way round, it's also what gives us as employers SOSR dismissals quite regularly. You'll often see at the end of a particular disciplinary dismissal letter, there'll be we're sacking you for gross misconduct, and then you'll get this line that also says you've destroyed the relationship of trust between us, etc., etc. That's in there because it potentially gives this as a backup if your dismissal claim is found unsafe. Somewhat beside the point, we'll come on to dismissals and unfair dismissals in a later session, of course. But there we go, express versus implied terms. So do bear in mind that all of those are in there, even if they're not written down. So what do we have to have in there? Section 1, Employment Rights Act 1996, Statement of Terms. Most of us don't do an isolated statement of terms. I think I will speak for almost everybody here where I say what you will draft or what you expect to be drafted is a more comprehensive contract that states that it incorporates that Section 1 statement of terms. I will be surprised if anybody does that differently, but it's not impossible. It's perfectly viable to do a almost tabular list of the statement of terms and then have a separate contract. Nothing legally wrong with that. But the Section 1 statement of terms is a statutory obligation to provide certain information immediately to employees, and following updates from the Good Work Plan over the previous sort of 5-6 years, workers now as well. Anybody who is not self-employed but is working with you should have an updated contract that covers every aspect of Section 1 statement, which includes all of the updates that were made over previous years. Section 1 tells us there's 3 types of information that we have to give people. There is information we have to give them immediately in a single document. There is information they should have access to immediately, but in some other readily accessible document. And there is information we can provide within 2 months of their start date. What are these 3? I hear everybody desperately asking. I won't cover all of them because the list is huge. But the stuff that has to be in the single document is the stuff that you would expect. It's the stuff that you would want if you were starting a new job. It's the core employment terms. Who are they? Who are you? What's the start date? How long is this intended to last for, particularly if it's a fixed term contract? Just as an aside, while we're on terms here, be careful of fixed term contracts, partly because series of fixed term contracts stacked end to end can be deemed continuous employment. and partly because even if it's not, if you have a new fixed term that lasts for more than 2 years, expiry of that fixed term is not necessarily a fair dismissal. It's not one of the 5 reasons that are set out in the Employment Rights Act. So just because you've got to the end of a 3-year fixed term period, it's not automatically safe to terminate that individual. We would expect rates of pay to be in there. We'd expect to know what our hours are, where we're working, what our holiday entitlement is. A lot of these are statutory rights, of course. Notice term should be in there, and requirements for service of notice. Put it in there even if it's statutory minimum, because the legislation says we have to put it in there. Probationary periods. Now, as an aside with probationary periods and the terms that you're using here, the legal value of a probationary period is to reduce a notice period during that probationary period. Okay, it's got no legal meaning in general terms. It doesn't help you in terms of an unfair dismissal because the employee is probably under 2 years anyway. But the benefit of a probationary period really is if you're going to start immediately with quite a long notice period, i.e. a month, your probationary period will say during the course of the probation, we can terminate on a week. And that is really the benefit of a probationary period more than anything else. It's obviously from a HR point of view got other technical and procedural benefits around reviews and making sure that everybody's on board, and reviewing at the end of a 3-month period, because that's when you're going to start getting things like pension coming into play and maybe other benefits. But from a real basic contract and actual employment black and white letter law point of view, it's relatively meaningless other than in terms of notice periods, but it's got to be in there. I've also mentioned training issues, so that is any mandatory training they're expected to do and who covers the cost of those and how that's funded. What I would not suggest you put in an actual employment contract is the training agreement and reimbursement of training fees. I would always suggest they're done separately, because if they're incorporated into the actual contract, it's very easy for the employee to go, well, I didn't actually understand that, I wasn't aware of that, and you'll just end up in a dispute as to whether it's binding or not. So if you're taking on staff and you're going to put them through long and expensive training processes, I would have a separate training agreement covering entitlement and, if you want it, reimbursement of those costs if they leave. The reasonably accessible document, so this is additional stuff which you would expect to crop up less regularly, but which an employee or worker will want to know about. So these are the more ancillary details as I've described them. Doesn't strictly need to be in the original document. Again, most people are, because we incorporate them all. Entitlement to sick, other forms of paid leave. The other forms of paid leave is an interesting one because the Good Work Plan changes to Section 1 were really vague on this. And I think what most people are doing now, certainly what we're doing, is simply listing any statutory entitlement they might have. So you'll see a clause that says you may be entitled to other forms of paid leave, including XXXXXXX. That seems to be a safe way of doing it for the time being, but the takeaway from this is you've probably also got a handbook that tells you what all those entitlements are. That's absolutely fine. Pension information and disciplinary and grievance procedures, and they're the ones that can come a little bit later. Again, disciplinary and grievance procedures are, I think, particularly the ones that are usually set outside of the contract because we all want to try and deem them non-contractual. That's obviously quite important because we don't want a failure to follow them to be a contract claim. Moving on. What happens if you don't provide this Section 1 statement? What happens if you don't provide a contract correctly? Well, the first point is you've got no documented record of anything that's been agreed. So default position is everybody's on their statutory rights, and whatever may or may not have been agreed between you is going to have to be deemed potentially through process of the county court, high court or tribunal trying to work out what the contract said. There is nothing worse, and my DR colleagues will absolutely back me up on this if I were to ask them, than trying to establish the terms of a contract that nobody's written down. And that, to be honest, is the most important reason to have one. From the employee's point of view, there is no freestanding claim of failing to provide a Section 1 statement. They cannot just turn up to tribunal and say, I've not been given my Section 1 statement, can I have some money, please? What they can do is tack it on to any other tribunal litigation, and it doesn't matter what that is. So if they have a successful unfair dismissal claim, if they have a successful discrimination claim, and they've not been provided a statement, they can still tack this on the end, and its entitlement is 2 to 4 weeks pay, subject to that usual statutory cap. So if you've just had a £10,000 unfair dismissal claim by chance, and you've not given a Section 1 statement, and they get another 4 weeks at £500, you've just added 20-25% to the payout that you've got to give this individual simply by not providing them that statement. There's no real excuse not to do it. It makes a lot of commercial sense to make sure you've got written contracts in place anyway. Additional things you might want to think about putting in contracts. There is a duty of confidentiality, I said, that is quite broad. It applies during employment. You probably want this to survive indefinitely afterwards, and I think contractual confidentiality clauses are usually a lot stronger. Post-termination restrictions, always a contentious one. These are the don't go and work for a competitor, don't poach our staff, don't poach our clients, sometimes referred to as restrictive covenants. So, same thing, really. If you are looking at putting post-termination restrictions in a contract, they need to be well drafted. It is perfectly possible to put these in and for them to be too broad, for them to be considered too onerous for an employee of a certain seniority or lack thereof. And it's very, very possible that they will be deemed unenforceable if they're not individually thought through for each employee, or certainly for each grade of employee. Realistically, in post-termination situations, and this is the advice we often give employers, you're putting them in to scare somebody into not doing something you don't want them to do. The chances of you going through the very expensive court proceedings of enforcing a post-termination restriction are probably quite low. They are expensive, they're not always upheld, and realistically, unless you can show some significant financial loss caused by an ex-employee doing something they shouldn't be, you're not going to be following these up. But you still want to be able to point to them and say, look, you're doing something you shouldn't be, stop, or we will sue. The more enforceable they are in theory, the more use that is to you as a threat, even though you may not be following through on it. For more senior staff in particular, other benefits and allowances, car allowances, differences in pension, share options, SIPs, LTIPs, all of this sort of stuff that you might want to consider incorporating into your contract. I've said there, if somebody is a director in particular, the additional duties that come with that. We know they've got their fiduciary duties under Companies Act anyway, but where you've got those, particularly in relation to a director, there may be situations where breach of those needs to give you grounds to terminate, which might not ordinarily. And I think what's important when you're thinking about bringing a director on board, and this is now rolling into point 3 here with service agreements, they are two different hats. Director and employee are, in a sense, mutually exclusive, and without a contractual provision to the contrary, one is not necessarily codependent on the other. So where service agreements differ from senior employment contracts is they will envisage these various situations where you may also want to terminate a director's employment if, for example, they're no longer a director, or vice versa, because these two things don't necessarily happen automatically. If somebody is both a director and an employee, just to use an example, disqualification as a director does not automatically terminate their employment as well. Of course, it's perfectly possible for someone to be a director and not an employee, in which case that makes no difference. But where they are, you want these additional contractual provisions in there to protect the company, and also to recognise the additional obligations, rights, and entitlements that that individual might be receiving. So that, I think, is it for the time being on contractual points and provisions. I've got one question that's cropped up. If a fixed 12-month term contract has been renewed annually for more than 2 years, where do you stand on the end of the term if it was at, say, month 36? Yeah, it's an interesting one with this sort of renewal of fixed term contracts. Do you want a clear answer on that, or do you want the tribunal answer on it? Because I mean, a tribunal will potentially say it depends on what the intention was here and what was actually um, uh, going on in practice. The tribunal is perfectly capable and has in the past looked at situations like that and gone, it's actually a 3-year employment. There are limited safe ways of doing this without a break, because if they deem it continuous employment, they will deem it 3 years employed and therefore statutory rights. Anybody, I'll just give you an opportunity to come back to me on that if you want to, or if anybody else has got anything they want to say differently on it. Yeah, I mean, yes, we know the limit kind of sits there, and you know, some jurisdictions you've sort of got this you can do it 4 times before anything starts to become more permanent. But having just looked at sort of Uber and auto cleanse, I think we're prepared to say the tribunal will do whatever they like if they think they can give someone employment rights where they should be entitled to them. Okay, last thing I particularly wanted to touch on today is this incredibly exciting piece of draft legislation that was put out a couple of weeks back. So this detours now from status and contractual relationships, so that it will touch a little bit on what we were saying. Here we go, classic UK employment legislation, the Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. Thrilling sounding piece of legislation. It actually does some things that are potentially quite exciting to us as employers. So these are currently just in draft form and apparently are due to come in on the 1st of January. Whether that will happen or not, who knows? They're intending to, but let's watch this space. First big thing that it appears to do, take us back to 12.07% holiday calculations, including rolled up for part year and irregular hours. This will, for those of you who are engaging staff on either part year, seasonal or very irregular hours, make life a lot easier. It sort of looks at the cases of things like Bear Scotland and Agnew and goes, this is just too complicated for employers. Everybody's getting holiday pay calculations wrong. People who work part year are getting more than the government thinks they should be entitled to. So we're going to go back to this really simple calculation, 12.07% of hours worked, and particularly useful for seasonal staff, this sort of rolled up holiday, you're being paid it. Rolled up holiday has been illegal for a long time. I know a lot of people still do it. Quite frankly, this will make almost no practical difference, because what the UK courts have always said about rolled up holiday is there's no loss. Yes, in principle, there's a claim that somebody has had their annual leave and they've been paid. So where's the loss? I mean, this makes a lot of sense from an administration point of view, if nothing else. 3 things there it's doing just to make sure we don't accidentally revoke any existing EU law around carryover. So this will preserve the right to roll over statutory holiday entitlement that is missed due to family leave. The Regulation 13, so that's the basic 4 weeks, not counting the public holidays that are missed due to illness, and Regulation 13, those 4 weeks leave where the opportunity isn't given to take it and staff aren't told that your policy is take it or lose it. So that will carry on as normal. We know that all of those things apply. It will helpfully define normal remuneration. So again, coming back to cases like Agnew and Bear Scotland, the ultimate challenge that started in the case of Agnew was the definition of normal remuneration. The working time regs tell us that holiday pay should be calculated on normal salary, and they were being paid it on basic salary. And nobody could decide where this sort of sat. So what we're probably going to end up here with is this definition of normal remuneration, which will be that calculation of a week's pay for holiday entitlement. And the statutory definition, hopefully, is going to clear this up and tell us that it includes regular overtime, regular commissions, things like that. Two other quick changes, and then yes, I'll come on to the couple of questions that I've seen pinging up. Additional working time record keeping. There was this ridiculous German, Danish, one or the other case that said basically even where you've got people working regular hours all the time, you're supposed to be keeping track of their work time for record keeping purposes. That looks like that's going to go. I'm sure everybody was doing it religiously. If you are, it looks like you don't need to as and when these regulations come into force. And there will also be some minor changes to TUPE consultation for small businesses. That's not very exciting. TUPE is not the most exciting thing to talk about anyway. If anybody wants to have a chat about a TUPE consultation for a small business, please do, and I'll explain any changes that might be coming up. Okay, couple of questions on this. Can I explain the term rolled up holiday? Yes, I can. So the idea of rolled up holiday was ultimately if you've got somebody who is particularly seasonal staff, this is more common, historically anyway, and increasingly for people who work either part of the year or on irregular hours, what you basically do is go, well, okay, you're entitled to X amount of holiday over the course of this period that you're working for us. Take it when you like, but we're not going to pay you for that day off. We're going to incorporate it into your salary payment. The EU didn't like this. I mean, in a sense, it doesn't matter because they're getting paid for that time. It's incorporated into their salary, as long as that doesn't take them below minimum wage, and they get required rest breaks. And it's a way of, when you've got somebody working with you for a very, very short period in particular, just making sure that they don't, I don't know, start with you in July for what is basically a summer job and take 6 days off in the middle of August, which is your busiest period. Principally, the EU didn't like it because it was discouraging people from taking rest breaks. Our view in our courts was kind of, well, actually, this contract only lasts 3 months anyway. We don't want somebody taking all of this off. I'm hoping that sort of makes sense, but what it means is your paid annual leave is rolled up into your normal salary. Does the rolled up holiday apply to 0 hours workers? Looking at the draft regulations, yes, probably, because they would cover irregular hours. So it does look as though you'll probably get away with that. What you just want to be careful with 0 hours workers is if they start to build up a regular pattern, even if contractually they are 0 hours. Again, these are still in draft form. They're still subject to amendment, so there might still be changes. Consultation period for changing a day off in an employee's contract. As in consultation period for changing the day off in an employee's contract. Could you just clarify what you mean by that one? Is it they've got a booked day and you want to change that, or is it you want to change their holiday entitlement? Day off is floating as they work on a rota basis. We want to anchor it. Okay, it's a change. Ultimately, that is a change to their contract. I don't think there's a sort of set consultation period per se, but because you're changing the contract, what you want to do is try and obviously want to try and get them to agree that to avoid any kind of breach of contract arguments. I suspect the easiest way to do that is going to be sit down, have a conversation, explain to them why you're doing it, and they're more than likely to agree, let's be honest. But no, there's no kind of defined consultation period for those discussions. They're going to argue they just want reasonable time to adapt to it. Any update on the proposed changes to flexible working provisions next year? Not that I'd planned for to talk about at the moment. I'm not aware of any particular changes other than those that we've already communicated. Watch this space. It is something that will probably come up in a later session anyway. As and when there's updates on things like that, we try to update people working through anyway. Should a contract state the start and end date of a holiday year? Yes, it's useful to, because otherwise you'll end up in this strange conversation where people don't actually know what their holiday year is and when they're supposed to be taking their entitlements. It also makes it quite difficult to calculate pro rata holiday entitlement if you don't know the applicable period. Normal remuneration to include regular overtime. So where we calculate normal remuneration at the moment, it is a 52-week reference period. It was increased from the 12-week period a couple of years back. Not clear from these draft regulations whether it's going to kick in from the 1st of January and just count moving forwards, or whether it's going to count moving backwards as well. As and when the final version of it is produced, we'll be able to advise accordingly. We've rolled up holiday potentially coming back with the immediate changes. So the question, because I know not everybody can see it, with the rolled up holiday potentially coming back, will there be any change to the reference period? Nothing in these regulations suggests there will be, so it will be presumably that 52 weeks. Okay, we're just about there. I'm going to have to finish up myself anyway, and I'm sure everybody else wants to get back to work. I think I've managed to cover most of the questions there. If there's any I haven't, please do feel free to drop me an email, give me a call, reach out on LinkedIn, whatever. That's absolutely fine. I'll help quickly if I can. Just quickly before we go, next session is going to be on Tuesday, the 9th of January. I know we said it'd be the first Wednesday. I assumed most of you would not want to join on your second day back. And I'm caught up on something else on Wednesday the 10th. So Tuesday the 9th, 10 o'clock, and we will be looking at the protected characteristics in the first of a two-part session on discrimination law. If I don't speak to any of you before, do have a wonderful break as and when you get there, and I will see you in the new year. Thanks for joining, everyone.